Okay, good afternoon, everybody in the city of Kodiak. Thank you for participating in our training this afternoon. I'm Carlene Mitchell. I'm the Deputy Director at Alaska Public Entity Insurance. I also do human resources related loss control training and consultation. And so we're here today to talk about preventing disability discrimination in the workplace. Okay, so to start off with, the Americans with Disabilities Act is a pretty comprehensive law. As it pertains to our presentation today, it talks about discrimination in the workplace. In addition to talking about the Americans with Disabilities Act, or ADA, we're also going to talk about the Alaska Human Rights Law, as it pertains to disability. In particular, we're going to discuss how the ADA and human rights laws prohibit discrimination in employment and the requirements that you have as an employer to provide reasonable accommodations to employees. So it's really essential that as an employer that you comply with the ADA and the Alaska Human Rights Law. And as your insurance provider, at APEI, our goal, we have a very vested interest in assisting our members in preventing any type of instance that can lead to insurance claims. For example, with any accusation of discrimination based on disability, that can lead to an employment practices liability claim. And those claims in particular can take years to resolve and cost thousands and sometimes even millions of dollars. So we are very interested in wanting to provide all the information we can to our members to help them prevent any claims that lead to lawsuits in regards to discrimination. So the ADA and the Alaska Human Rights Law both make it unlawful to discriminate in employment practices, and that includes recruitment, pay, hiring and firing, providing training, assigning jobs, promoting and even demoting employees, in the provision of benefits, providing tenure, if you're laying off employees, in providing or approving leave, and all other employment-related activities. So in addition, the ADA prohibits an employer from retaliating against any employees or applicants for asserting their rights under the ADA. So for example, if you had an employee who requested a reasonable accommodation and say, for example, the supervisor didn't follow up or they disregarded that request, and then the employee sought assistance from a higher level manager or maybe even an outside advocate to obtain that accommodation. Even if that accommodation was provided, if the manager or anybody else with the employer in general then took negative action against that employee, that could be considered retaliation. Now, there are legitimate business reasons for taking a negative action. For example, providing feedback on poor job performance or not promoting an individual if they're not qualified for a position. But you really need to make sure that when you are making those business decisions that they are based on a legitimate business reason, and do what you can to prevent the perception that those decisions were based upon a discrimination based on disability. You really have to be able to back up those employment decisions. The other thing too about the ADA is that it not only applies to employees that have a disability themselves, but it can also apply to an employee who has a relationship with somebody who has a disability. So it might be their spouse, it might be a child, or another individual in their life. So for example, if you had an individual who applied for a job with the city of Kodiak and they didn't get hired for that job because maybe the hiring manager knew that the individual had a spouse or a child that had a disability, and they were concerned that because of that relationship, this individual might not be able to fulfill the requirements of the position. If that was believed to be the case, that could be considered discriminatory. So the Alaska human rights law also makes it illegal to discriminate, not only because of disability, but you'll recognize these other protected classes here: race, religion, color, national origin, and sex. In addition, in employment and other situations, the Alaska human rights law also makes it illegal to discriminate on the basis of age, marital status, changes in marital status, pregnancy, or parenthood. And if those are familiar, it's because, of course, there are federal laws under the Civil Rights Act that cover most of those. The one that is primarily different is the changes in marital status and marital status. But again, for the purposes of this training, we're just focusing on the disability aspect of this law. It just happens to be in Alaska. This one law is all-encompassing. Okay, so the Alaska Human Rights Law, just like the ADA, also makes it illegal for an employer to retaliate against an employee for opposing any practice that's forbidden under the human rights law, or because the person has filed a complaint or they assisted in a proceeding under the human rights law. So the human rights law and the ADA are very, very similar. Of course, both of these laws have an enforcement agency. The ADA is a federal law that is enforced by the Equal Employment Opportunity Commission, and in Alaska, the human rights law is enforced by the Alaska State Commission for Human Rights. So if an individual feels that they have been discriminated against, they have the right to file a complaint with one or both of these organizations. It is actually rather interesting to go to the State Commission on Human Rights website and take a look at their reports, their annual reports on the investigations they did and the findings and the results. It's really eye-opening to see what kind of complaints are coming in and by what class. Okay, so we've taken a quick look over each law, the ADA and the Alaska Human Rights Law, but we need to get into a little more detail on the definition of what a covered individual is under these laws and also how impairment is defined. This is part of this presentation. Is going to have a lot of detail, so you'll pardon me as I read through these slides for that specific detail. So first of all, covered individuals. Who is a covered individual under the ADA? So employment discrimination is prohibited against any qualified individual that has a disability. And covered individuals can include applicants for employment as well as an employee. So it doesn't have to be someone who is actively working for your organization. So persons that are discriminated against because they have a known association with a relationship with an individual with a disability are also protected. So just as I said, the spouse, their child, someone else close to their life that they may be providing care for, if they feel they're being discriminated against for having that relationship, that also could be the basis of a complaint to the Human Rights Commission or to the EEOC. So as defined by ADA, what is a qualified individual with a disability? So that qualified individual is any individual with a disability who satisfies the requisite skill, experience, education, and other job-related requirements of the employment position such individual holds or desires, and, not or, but and, an individual who, with or without reasonable accommodation, can perform the essential functions of such a position. So what you're looking for is that individual who has the requirements for the position and can do all of the essential job functions with that position, either with or without reasonable accommodation. And in all likelihood, your job descriptions and your job ads state that you're offering this job, here are the essential functions, and are you able to do this job with or without reasonable accommodation? So if you're looking at a job and what functions are considered essential for that position, take into consideration that does that job exist to perform that particular function? If you're hiring someone to be a crane operator, you need them to be able to operate a crane. Or that the function of that job, it requires a specialized skill or expertise that you're hiring that person for. So if you're hiring a finance director, clearly they have to have a degree and background in financial management. Also, an essential function is one that it's only a limited number of employees perform that particular function. So a lot of jobs, we probably all have some degree of administrative filing to do. For most jobs, that's not going to be an essential function. Maybe it will be for a records clerk, but for most jobs, if somebody cannot file, that's probably not going to be an essential function of their position. And finding ways to accommodate that is appropriate. Okay, so how do you determine if an individual is considered to have a disability? So a covered individual with a disability is an individual if he or she has a physical or mental impairment that substantially limits one or more major life activities, or if they have a record of such an impairment, or if they're regarded as having such an impairment. So in particular, that substantially limits, that's the term that you want to focus on, that means that it's an impairment, it's a disability if it substantially limits the ability of the individual to perform a major life activity compared to most people in the general population. So it's important to note that the impairment doesn't need to prevent or significantly or severely restrict the individual from performing a major life activity to be considered substantially limiting. So for example, you might have somebody who walks just fine. They are absolutely mobile, but perhaps due to, say, a heart condition, they can only walk short distances or walk for short periods of time. That heart condition is the disability that substantially limits their ability to walk, but they can walk. So it's not always readily apparent. So a physical or mental impairment, what does that mean? So by the definition, it's any psychological disorder or condition, physiological disorder or condition, cosmetic disfigurement, or an anatomical loss affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, including your speech organs, cardiovascular, reproductive, digestive, genitourinary, hemic, lymphatic, skin, or endocrine, or it's any mental or psychological disorder such as mental retardation, organic brain syndrome, emotional or mental illness, and specific learning disabilities. So then, what is considered a major life activity? Okay, ADA defines this as caring for oneself, performing manual tasks, the ability to see, hear, eat, sleep, walk, stand, sit, reach, lift, bend, speak, breathing, learning, reading, concentrating, thinking, communicating, interacting with others, and working. And also the operation of a major bodily function that includes functions of the immune system, special sense organs and skin, normal cell growth and digestive, genitourinary, bowel, bladder, neurological, brain, respiratory, circulatory, cardiovascular, endocrine, hemic, lymphatic, musculoskeletal, and reproductive functions. So the operation of a major bodily function, it can include the operation of an individual organ within a body system. So one of the things this brings about, of course, is the idea that not all disabilities are going to be visible and clear. It's very easy to imagine somebody perhaps that is in a wheelchair, or they're hearing impaired or visually impaired. But it's very different when somebody has a medical condition affecting one of their bodily organs, where you see them day to day and you don't recognize that they have a medical condition, but it absolutely may be impacting their ability to do certain parts of their job. So whether or not an impairment substantially limits a major life activity, that needs to be made without regard to, and I love this word, ameliorative effects. Ameliorative effects, that's something that makes it better, of mitigating measures. So easily said here is that you're looking at mitigating measures such as medication or medical supplies, low vision devices, prosthetics, hearing aids, mobility devices that help make that medical condition better or easier to bear. And so in this particular case, you may have somebody who's taking a medication that helps alleviate many of their symptoms of the medical condition they have on a day-to-day basis, but it doesn't mean that they no longer have a disability. As a point of clarification, you'll see here it notes that low vision devices, it doesn't include ordinary eyeglasses or contact lenses. So most visual impairment that we have, your average person, I wear reading glasses now and then. Probably many of you also wear glasses or contact lenses. And in that situation, that's not considered a disability under ADA. It doesn't substantially limit a major life activity, but there, of course, is a level of visual impairment that would substantially limit. So that would be the differentiation. So the ADA was amended at one point. So we have the ADA Amendment Act, or the ADAAA, that in addition to other changes, one of the things the ADAAA specifically states now is that there are certain conditions that you can easily be determined to be covered as a disability under the law. So in those particular situations, if you have an individual that has epilepsy, paralysis, HIV infection or AIDS, a substantial hearing or visual impairment, cancer, PTSD, obsessive compulsive disorder, MS, muscular dystrophy, a major depressive disorder, bipolar disorder, schizophrenia, autism, intellectual impairment, mobility impairments requiring the use of a wheelchair, and partial or missing limbs. Under the ADAA, these have been determined to be covered disabilities. So there should not be a question if somebody has clearly this disability or a diagnosis of. So we've looked at the ADA. We need to now look closer at Alaska Statute 1880, which is the Alaska Human Rights Law, and their definitions. Now you will recognize that these are really very similar to ADA, but again, I do need to go over each of them. So Alaska Statute 1880-300 defines physical or mental disability as a physical or mental impairment that substantially limits one or more major life activity, a history of or a misclassification as having a mental or physical impairment that substantially limits one or more major life activities, or a condition that may require the use of a prosthesis, special equipment for mobility, or a service animal. It's also defined as having a physical or mental impairment that does not substantially limit a person's major life activities, but that is treated by the person as constituting as such a limitation. That's very broad. A physical or mental impairment that substantially limits a person's major life activities only as a result of the attitudes of others towards the impairment, or none of the impairments defined in this paragraph, but being treated by others as having such an impairment. And I want to talk about those two bullet points, those last two, real quickly. So what those two in particular are saying is somebody doesn't necessarily have to have an impairment to be treated by others as if they do, and therefore to be able to make a complaint about discrimination. So a good example of this is if somebody was treated as if they had perhaps a mental illness, or they were mocked because somebody teased them about perhaps having a learning disability, whether they did or not, that would be considered discriminatory. So that also needs to be, you need to be aware of in your workplace. But you see that third bullet point has an or at the end. So having a condition that may require the use of a prosthesis, special equipment for mobility, or a service animal. And of course, then physical or mental impairment means a physiological disorder or condition cosmetic disfigurement, or anatomical loss affecting one or more of the following body symptoms. And these, again, are very, very much the same as under the ADA, so I'm not going to repeat them at this point. And also the mental and psychological disorders, again, are very, very similar to the ADA, and I believe they are all encompassing there. So we need to also talk about under ADA, alcohol and drug use. So first of all, alcohol. So it's important to point out that just because an individual currently uses alcohol, it doesn't automatically deny them the protection of the ADA because of that use. So you might have somebody that has a disability, and maybe in your personal opinion they shouldn't be using alcohol, but that is irrelevant. So an individual, though, that is an alcoholic is considered a person that has a disability under ADA, and they might be entitled to consideration for accommodation if they're qualified to perform the essential functions of the job. So if somebody is seeking treatment for alcoholism and they need to go to therapy or meetings for treatment, then they may be eligible for accommodation. However, it doesn't mean that just because somebody has been diagnosed as an alcoholic that it is appropriate for them to come to work under the influence. Your same organizational policies would apply if somebody came to work under the influence of alcohol, and if that alcoholism impacted their work. So you still have the ability to discipline or terminate an employee for violating policies in your organization regarding the use of alcohol. Similarly, with drug use, a drug addict is protected as having a disability, but only if they are receiving or have received recovery treatment and they are not a current users. So an individual that is addicted to drugs, but they're no longer using drugs illegally and they're receiving treatment for addiction, or they have been rehabilitated successfully, they're protected by the ADA from discrimination on the basis of their past addiction. So you may be aware that somebody has had an addiction issue in the past, but if they have recovered, that is not sufficient reason to not hire them for a position if you don't trust that they have recovered. You need to show the business case for why they are not eligible for the position. Okay, so we have just gone over a whole lot of very detailed information, and I think it's really important to point out that I don't expect any of you to have all of these definitions memorized. I think that just to have a good understanding of what the ADA covers and being aware that it's very broad in the definition of a disability and who is covered is the most important thing. If you have a situation where an individual comes to you requesting accommodation and there's some question as to whether or not they are a covered individual, you can take a look back at those laws and the particular definitions. But what I think is most important about this training, the most important aspect is that is coming up next, and that's the discussion of reasonable accommodations. This is where ADA and the Alaska Human Rights Law really become important for you as an employer. So reasonable accommodation is any modification or adjustment to a job or the work environment that will enable a qualified individual with a disability to participate either in the application process or to be able to perform the essential functions of a job or those fundamental duties of their job. So reasonable accommodation, it can also include adjustments to ensure that a qualified individual with a disability has the same rights and privileges in employment that are equal to employees that do not have a disability. So another important thing to point out too is when you're making reasonable accommodations, they may be on a permanent basis for somebody who has a medical condition that is ongoing and will not go away. But also reasonable accommodation applies to temporary disabilities. So for example, if you have somebody who has injured their back and for a period of time they need to be accommodated to be able to complete the essential functions of their job, it may be on a temporary basis. So you're looking at both permanent and temporary accommodations. So just a real short list of some basic examples of reasonable accommodation. They can include things that are very obvious. For example, providing special phone for a receptionist who has a hearing impairment. Another common one would be larger screens for computer screens for someone with a visual impairment. It can also be something like providing frequent stretching breaks for an employee who has a muscular or a joint or a vascular disorder, and their job requires long periods of sitting or standing, and they need to get up and move around. I once worked with an individual who requested an accommodation. They had injured their back, and it was difficult for them to sit for long periods of time, and they wanted a standing desk. And so we arranged for them to have a standing desk, and we got them a chair that was bar stool height, and that made all the difference in the world for them to be able to do their desk-related work. This can also be modifying an employee's work schedule to allow them to attend treatment or appointments related to their disability. So again, going back to the situation of an individual perhaps who is seeking treatment for alcoholism, and they want to attend meetings, AA meetings, then adjusting their schedule to allow them to do that as needed would be a very appropriate accommodation. Adjusting supervisory or training methods for an individual with a learning disability. If your typical training for a new employee is to hand them a printed manual for them to sit down and read in order to learn a part of their job, that may not work for somebody who has a learning disability. You may need to find another way to accommodate that individual so they can learn all the aspects of their job. And of course, job restructuring or reassignment. So you reassign someone to another position. Often this is on a temporary basis until they recover from a medical situation. Or if you have somebody who experiences a new medical situation that is going to not end in the foreseeable future, you may be discussing with them a new position in your organization that allows them to continue working for you. So these are all part of the discussion that is going to take place with an individual when they come to you and you begin discussing reasonable accommodation. A really important thing here is that under the ADA, the accommodations that you provide an individual are all determined on a case-by-case basis. There is no checklist that you can go through to make sure that you are offering an individual the accommodation they need for their specific disability. So this is really dependent on a wide variety of things in the accommodation that you can provide them and that they will be able to do. So they all need to be looked at on a case-by-case basis. A really important thing about making reasonable accommodation is understanding that you are not required to tolerate poor performance or poor attendance, for example, that is unrelated to a disability. That is not an accommodation. One of the things I hear a lot about is I attend an HR conference every year and we go over different case laws in different presentations, and ADA is a big law for them to discuss. And accommodating employees by allowing them time off of work, allowing absences, is a really, really common accommodation. But what it does not mean is that you have to give employees all the time off that they want. At some point in time, you need to determine if the accommodation that you're providing for the employee is reasonable. So accommodations need to be reasonable and they should not create an undue hardship for you as an employer. It's really important though, that undue hardship standard, it's pretty high. You would need to very, very clearly identify why a particular accommodation is unreasonable and that it presents an undue hardship on your organization. If you have an employee who comes and says, I need to take 6 months off of work, well, in some cases that may be covered partially under, for example, FMLA or AFLA. I know we discussed that back in January when I was in Kodiak. But part of that too is if the person needs leave that extends beyond that, or they have already used that entitlement, then you're not required to give them indefinite amounts of leave to accommodate them. There's a considerable amount of case law in which the various courts around the country have backed the employer when an employee has sued for discrimination based on disability, when the employer would not give them all the time off they wanted, or in situations where the employer would not give the employee exactly what they wanted. But be prepared to be able to back up why it is that you feel that an accommodation creates an undue hardship or is not considered reasonable. So when you're looking at undue hardship and how you would meet that standard, be thinking about actions that would require significant difficulty or a pretty high expense. And that would be in light of factors, for example, the nature of the accommodation or the cost in relation to the size of your organization, the resources you have available, the nature and structure of your operations. So it would, I think, go without saying is that, for example, the city of Anchorage probably would have an easier time in providing accommodations than the city of Kodiak because you're much smaller. And likewise, the city of Kodiak, which is on Prince of Wales Island, is much smaller than Kodiak. They might have an even harder time providing an accommodation compared to Kodiak. So there's a size relation consideration there when determining if an accommodation will create a significant difficulty or expense for your organization. But as I said, you do need to look at each of these on a case-by-case basis. And it's really important to make sure you partner with your human resources department before you make any disability-related inquiry of an employee. So if you think that they might need an accommodation before you have that conversation with them, or when you start assessing what a reasonable accommodation would be and what constitutes an undue hardship. So take the time to ask the appropriate questions, plan ahead of time with your HR department, and prepare for that conversation with the employee. As always, anytime you're dealing with an individual's medical information, it's really important to maintain confidentiality and privacy of that individual. This information should be on a need-to-know basis only. So navigating the ADA. So this law, again, it really scares people. When I talk to employers, I tend to see when they're struggling with it, things tend to be happening on one end of the spectrum or the other. Either the employer is like totally ignoring the law because they're so overwhelmed by it, or they're giving the employee everything that they could possibly want, the sun and the moon and the stars, tons of leave, whatever they want, because they are so afraid of being accused of discrimination. But as an employer, you do have rights. So I want you to be aware of those rights. The other thing that really puzzles employers is at what point does the need for reasonable accommodation kick in? What triggers that need? And that can be really broad. There can be a lot of different situations that occur that lead us to begin the discussion with an employee about reasonable accommodation. This discussion, it can be particularly difficult when you're dealing with behavioral or performance issues right as a disclosure comes about. So you sit down with an employee, you point out to them areas of their job performance that is deficient or their absenteeism, and they say, well, the reason I'm having these problems is because I have this medical condition. You need to navigate those situations very carefully, but pay attention to that information. And again, this doesn't mean you suddenly have to give them whatever accommodation they want. You do have the right to ask questions. So what that brings about is the interactive process. So the ADA in particular defines this interactive process. It's an informal practice in which the covered individual, that employee, and the employer take the time and have a dialogue back and forth to determine together what are the precise limitations that are created by the disability that the individual has, and what is the best way to respond to the need for the accommodation for that employee. So like I said, this request, it doesn't necessarily have to have the individual come and say, I want a reasonable accommodation because I have a disability as defined by the Americans with Disabilities Act. I think you'll find most people aren't that familiar with the law and they don't always know to come to their employer and ask. And let's face it, some disabilities and medical conditions might be a little more difficult to discuss, and they may be hesitant to talk out to their employer about those things. Some people are very, very private about their medical situation. So what it is that it can trigger an employer's obligation to respond is any communication that you receive that indicates the employee's need for some type of they've had some type of change due to a medical condition. So the nature of that communication, it might be unclear or vague, and it might be necessary for you as the employer to ask for clarification and more information. That's that interactive process. So this can be a conversation between the employee and the supervisor or the employee and HR, but at some point I really feel it's important to include the employee, their direct supervisor, and the HR manager in the discussion on providing that accommodation so everybody's on the same page. So also be aware that a request for accommodation, it might not necessarily come directly from the employee. They might be walking in with a doctor's note, and often this shows up with the employee who's been out for several days seeking medical treatment, or they have come in with a request for leave under FMLA or AFLA or both. And their doctor's note might identify some medical restrictions that you need to take note of as an employer and start thinking about if this could be an ADA accommodation situation. It's also possible that you might get information from a family member or some other representative about the individual. The employee doesn't show up to work and their spouse calls in and they share with you what the concern is. So any communication that brings to light that possibly this individual has a medical situation that may require some accommodation. So if the disability and the need for accommodation is not obvious, the employee doesn't need to expressly ask for reasonable accommodation, but it is important to ask and seek information from the employee. So in that interactive process, what you want to try and find out is, what is it the employee is asking for? This really has to be something concrete. So an employee identifies for you that they are struggling with areas of their job. An appropriate question to ask is, do we need to provide accommodation, and what do you feel would be an accommodation that would allow you to complete the essential functions of your job? And this could be a fairly lengthy conversation. It may take several days or weeks to identify exactly what that appropriate accommodation is going to be. So this is also the perfect time to pull out that individual's job description and start looking over their job duties and go over with the employee, what particular duties is it that you're having difficulty completing? Are these essential job functions, or are they more marginal functions of the job? Focus on those essential job functions. Marginal job functions, that maybe they can be allocated to somebody else. But those essential functions, what in particular is it that they are struggling with? Sometimes that job description needs to be given to the employee for them to take to their medical provider, so their medical provider can review it and provide feedback on what it is that might be a reasonable accommodation for the employee. So then you want to identify potential accommodations that will work for this employee, but also work for the employer. So ask yourself and the employee, is that proposed accommodation, is it truly going to be effective to enable that employee to perform the essential functions of their job? It may seem that way, but then you also need to assess the effectiveness of each potential accommodation. That could be through discussion right there during that interactive process, or you might be putting an accommodation into place and then continuing to assess the individual's job performance to see if that accommodation is making a difference. We talked again initially about job performance issues, and I mean the reality is that maybe somebody has a disability that is impacting their ability to do their job, and as soon as you give them that accommodation, their performance improves and everything's great. But we also may have a situation with somebody who is either unwilling or unable to do a particular job, despite what they felt initially when they took on this job. So you need to assess that accommodation and make sure it is working. You still need to make your expectations clear. Again, when I was there in January, we talked a lot about this, about communicating with the employee and providing specific feedback, immediate feedback to the employee in regards to exactly what areas of their jobs is not being completed. So what essential functions are not being met, and what needs to happen to allow them to meet them. So as you're looking at accommodations, certainly consider the employee's preference, but then you also need to think about selecting and implementing an accommodation that's most appropriate, not only just for the employee, but for the employer as well. Again, what the employee feels like would be absolute best may not necessarily be the best thing for you as an employer, may again present that undue hardship. So having a discussion back and forth and having good communication in which you mutually come to an agreement on that the most appropriate accommodation for the employee and the employer is really, really essential. So supporting documentation. As an employer, you do have the right to request documentation from an employee that provides information about their disability. If an employee comes to you and says, I have a medical condition and you have to accommodate me, and you say, okay, can you provide me with that documentation? And they say, no, you have to do what I want because I'm protected under ADA, that is not correct. If the condition that they're describing is not readily apparent, you do have the right to request information that backs up their request for accommodation. So the documentation that you may require, it has to be sufficient to substantiate that the employee has an ADA disability and that they truly do need this reasonable accommodation that they are requesting, but you can't request unrelated documentation. So you can't ask for their entire health history for you to review and check up on. If an individual is stating a specific disability that they feel that needs to be accommodated, that's the one you would focus on and request documentation about. Now, if an employee provides insufficient documentation or no documentation and the employer feels it's necessary to request it, you don't have to provide the reasonable accommodation until that sufficient documentation is provided. Now, I think some situations are going to be pretty apparent. You have the employee who already comes in with a broken leg and they have a cast on their leg. It's going to be pretty apparent that you probably need to help them out to some degree, accommodate them to some degree if their job requires a lot of walking or moving around. But other things, other medical conditions are not so apparent. So again, you can ask for that documentation. And if they just flat out refuse and say, no, that's none of your business, you have to accommodate me, you don't have to accommodate them until they provide that documentation. Now is a good point for me to state that all along this process, this interactive process, it is absolutely imperative that you document that interactive process all along the way. The dates that you had conversations, who was involved in those conversations, what was discussed, what was decided, what was requested, when you requested information back by. Don't sit back and just wait for the employee to come back to you. If you have requested specific documentation from an employee and they fail to follow up, go to them and ask for that information again and document that you have done so. And again, if they don't follow up, go to them again and ask for that information again. If you ultimately have an employee who refuses to provide the documentation that you are requesting and they refuse to provide it and they are still not performing the essential functions of their job and you begin moving towards termination, you want that clear documentation to show that you engaged in that interactive process, but the employee did not come back with what you requested and did not fulfill their obligations. And therefore, you can justify your next step if you move towards termination. So definitely document if the employee does not cooperate in that interactive process. So is supporting documentation sufficient? It should be sufficient if it describes the nature, the severity, the duration of the impairment, the activities that that impairment limits, and the extent to which that impairment limits the employee's ability to perform the activity or their essential functions of their job. And it should substantiate why the request for reasonable accommodation is needed. Often a medical provider will even make suggestions as to what will be a reasonable accommodation. So there's situations where documentation might be insufficient. So for example, if the healthcare professional doesn't have the expertise to give an opinion about the employee's medical condition and limitations that are imposed by it. So if an employee is coming to you and saying they have a mental health issue and they're bringing you a note from their chiropractor, that's not the individual that you need that documentation from. You can look at that, look at the doctor's signature and the name, and look up and make sure that that is the appropriate individual to certify this the employee's need for an accommodation. Or perhaps the information that doesn't specify the functional limitations that the individual has because of the disability. It doesn't give you the information you need to really help the employee to work with the employee to determine what a reasonable accommodation is. Of course, there's other factors that could indicate that the information that the employee's brought you is not credible or fraudulent. I had an employee one time who brought in a doctor's note, and it was scribbled down on a blank white piece of paper. It was very basic, and the signature was illegible. And we asked, who is this doctor? And they couldn't give us a name. So if you see a name on this letter, and you can certainly, if you can't read it, you can ask what the doctor's name is, ask if there is a doctor in your community, or is this a doctor from Seattle or Anchorage? How can you identify who this is? It's okay to question the content of that documentation. Okay. So in general, best practices for reasonable accommodation and complying with the ADA and the Alaska Human Rights Law is understand that ADA, it demands a process, not an outcome. And again, as I said, each case under the ADA, each case of reasonable accommodation needs to be looked at individually for that particular individual, their particular disability, the extent of that disability, the particular job they do, the environment that they work in, how long that accommodation might be needed. There are a very, very wide number of topics that need to be covered on a very individual basis. So focus on that process and not just the outcome. Another best practice is certainly don't prejudge the outcome. It's really challenging sometimes when you have, especially an employee that you're already challenged by their performance issues, and then they're asking for reasonable accommodation because they're stating that they feel that their medical condition is leading to their performance issues. Remain neutral. Don't prejudge this outcome. Don't assume that this whole interactive process is just going to lead to a moot point. Follow through with that accommodation request and document very, very carefully all along the way the actions that you take in that process. So when an employee comes to you with an accommodation request, listen to them attentively. Listen to their requests and perform that customized inquiry with them, with their supervisors, and with HR's involvement to make that determination as to what an appropriate accommodation is. Keep in mind there can be several reasonable options for accommodation, and narrowing down which one is the best for everyone involved is going to be key. And of course, focus on the process that gets a fair result. And that's not only fair to the employee, but fair to you as the employer. You have rights as well. Don't let this law frighten you. There are a lot of resources out there. I'm happy to help. Your HR manager is happy to help. And it does require continuous discussion with the employee. On that same note, one of the things I want to really stress in this process is that you keep the channels of communication open with the employee. If you attended my training in January, one of the things I talked about is that if you do not communicate actively with employees and provide them with the information they need, they will fill in the blanks with whatever it is that they think is right. So if you have an employee who requested time off as an accommodation and you deny it and don't provide any other information, then they may begin inventing in their mind that you're just being inflexible and you're being discriminatory because of their disability. But if you communicate that clear, legitimate business reason why you cannot accommodate a leave request and document that, then even if they make that accusation, you have your documentation and your clear business reason, legitimate business reason for backing yourself up. And of course, the mantra of HR, document, document, document. All of these conversations that you have, all of the steps you took, the responses that you received from the employee, and then the ultimate outcome of that interactive process. Keep in mind that interactive process could be something that is ongoing throughout the life of the individual's employment with your organization. So medical conditions change and it might require some adjustment to that accommodation over time. But it doesn't mean you have to let down what your standards are for a particular job, what your expectations are for that position, and what is needed to complete that position. So as I mentioned, like I said, this law, it does scare people, but there are a lot of resources. So the EEOC enforcing guidance for disability-related inquiries and medical examinations, it's available here. I've provided the link. The EEOC in general has a ton of information on their website to guide employers in anything related to discrimination or harassment in the workplace and preventing those things from happening. Also, the Alaska State Commission for Human Rights has information on what is required in the state of Alaska, but absolutely as it applies to disability, one of my favorite websites to refer employers to is the Job Accommodation Network, askjan.org. This particular website has a ton of information. First of all, it really outlines the ADA nicely for employers to help you understand it in more layman's terms as to how to comply with it. But it also lists a whole bunch of medical conditions and potential accommodations that you might consider for an employee and how you can implement those accommodations. It is a wealth of information that I absolutely recommend that you check out if you have somebody who comes to you requesting an accommodation. So that is the end of my presentation. Again, I want to thank all of you for attending, and I certainly invite you, if you have questions about the ADA, about the Alaska Human Rights Law that you would ever want to ask, I am available to answer questions for APEI members, managers in particular. I'm certainly happy to hear from you. My contact information is available on APEI's website, which is akpei.com. And you can find my contact information and always email or give me a call anytime you'd like. So thanks very much.